Good afternoon and welcome. Welcome to the 17th day, as we had done in the morning, but this is a very special session. We have very, very special people, and I think we will go one by one because of time factor. First, let me welcome into our midst Professor Rajkumar, the Vice Chancellor of OP Jindal Global University. You see Professor Rajkumar there. And then let me also welcome Professor Stephen Marks, who will be handling the session. I will introduce Steve Marks a little later. I will do Raj first. Professor Rajkumar will be with us for 5 minutes. He will talk to you for 5 minutes and then leave.
I'll spend half an hour, Henry.
Oh, Muddy, half an hour. Sure. So that's such a gift to us. But the point is that he was just saying that he had done 200 webinars in the last 60 days, 260 days. Correct?
Yeah, correct.
200. Okay, 200. So all the participants here, I'm going to say a few things which Raj may not like, but I say it because we need people like this to encourage us in the work that we are all engaged in, not only in the course that we are engaged in, but in the various tasks that you are engaged in, as many of you academics and students. Here you are meeting the youngest Vice Chancellor of this country. And I will not guess, I don't want to even guess and mention how young he was or how old he was when he took over as Vice Chancellor. I leave that to him. But it is that things are possible. He is an architect who built physically that university and then took over as its first Vice Chancellor. And for us from Tamil Nadu, and I always say it, Raj, never have I said it in front of you, we are so proud that you are from the state of Tamil Nadu. You are from here. Your father is a close friend of ours. His father was Professor Chokkalingam, the retired Vice Chancellor of the the Manonmunian Sundarnar University, and the present Vice Chancellor of the
Rajiv Gandhi Youth.
Rajiv Gandhi Institute in Sri Perumbudur. So, Raj has a doctoral degree from the Faculty of Law from the University of Hong Kong, a Master of Law from the Harvard Law School. He has a Bachelor of Civil Law from the University of Oxford in the United Kingdom, the Bachelor of Law from the Faculty of Law of the University of Delhi, and a Bachelor of Commerce from Loyola College in Chennai. He has a whole list of awards, scholarships, and fellowships. I am passing it all on to you. A whole list of research grants and funds that he has been able to access. He passed the New York bar exam in July 2001 and was admitted to the bar of the state of the New York, USA as an attorney in that year. Admitted to the Bar Council of India in the year 1997. And the list goes on. I'm not going to get into that. But has built in the process this wonderful university, and a university which is unique in terms of its quality and standards. I have had the privilege of doing 1 or 2 programs in the university and therefore entered the premises, stayed in the premises. And the Vice Chancellor's room, my dears, is a glass room. So you see whether the Vice Chancellor is actually working or having only a cup of tea or chatting away. Everything is visible. The Vice Chancellor's room is open. I think the Chairman's room is also open. All these are glass. You can see them. Whatever is happening in that room is visible to all students who pass through that corridor and faculty who pass through that corridor. This is the work he does. In almost all human rights areas, you have the university intervening these days, and I want to congratulate Raj for that kind of a standard that he has set. It will be very, very difficult for people to keep up to those standards, perhaps, when he steps down from his position. So thank you, Raj, for being with us. I won't take more time. You are going to be an inspiration to a number of people who are going to listen to you. And then when you finish, then I will introduce Steve, and then we will get into the formal session. Thank you, Raj. Welcome.
Thank you very much, Henry. First of all, I really want to thank Henry and his organization, IHRE of People's Watch in particular. I would consider myself very fortunate to be part of a generation who has very intimately seen the evolution of People's Watch from the kind of organization it was, more focused in certain domestic issues of human rights, and now to become a national and an internationally respected organization that has worked in the field of human rights. And I can tell you that, and I don't need to tell you because all of you have been in this field, it is only fair to say that it is not easy and rather extremely difficult, if not hugely challenging, to be able to work in this field and to be able to maintain integrity and rectitude in that process. Henry Tepene has precisely done that and has galvanized social consciousness to a generation of young people and others to bring together their own interests and expertise in advancing the cause of human rights. In this context, Henry has suffered significantly. His family has suffered, not just in terms of inconveniences, but even at times physically. He has spent a lifetime of speaking truth to power and to ensure that the work relating to human rights achieve the highest priority, not only individually, but institutionally and collectively, bringing together so many people and institutions to advance this cause. So I'm very, very delighted that People's Watch has brought together so many of you to have this conversation. The substantive part of today's talk will be given by Professor Stephen Marks, who himself is an institution and a great source of inspiration for me personally. And we're very, very fortunate that Steve happened to be in India and has been on our campus and is able to give this talk today at a time when the world is obviously facing an extraordinarily difficult, pandemic. What I want to do is that I want to tell you that, why should we have hope for the fight in relation to human rights? We are indeed facing a lot of challenges today, challenges of numerous kinds. Not that we didn't face these challenges before, but today's challenges at one level, the world is facing an extraordinary sense of uncertainty, an extraordinary sense of urge to deal with this problem. Lives are lost, and more importantly, livelihoods are lost, and even the ability and one of the unique dimensions of this crisis is also because of the fact that there is no clear end date to this crisis. And we have seen that whenever crises happen and tend to happen, there is a natural, let's say, groundswell to, let go of our most fundamentally cherished rights and freedoms. There is a natural tendency for people to take the route of expediency and to somewhat, let's say, ignore and be indifferent about the need for protecting rights and freedoms. And also, it gets even more difficult that governments, not just in India, but around the world, somehow this is a moment when rights and freedoms can receive lesser priority and lesser attention, and the larger priority with regard to what we have to address in relation to public health and all of that, or protecting lives or protecting the economy, all of those things get greater attention, greater priority. So this is also a moment for us to, let's say, speak in one voice to once again recognize the importance of the work that all of you are doing. There is no better time to, let's say, come together and recognize the value and importance of the work that human rights practitioners like you are doing, not only because of the fact that it actually helps us fulfill and better understand what we are facing today, but also it actually creates a deeper sense of accountability of all exercise of power. I also want to mention that today, while the broadest sense of civil, political, economic, social, and cultural rights, all of them have had different levels of, let's say, challenges it has faced in relation to its enforcement and implementation, we have come a long way when it comes to the normative recognition of human rights, both domestic and international. The fact that we remain a committed democracy is also a very important part of one of the most fundamental rights, which is the right to have a democratic form of government. The fact that we have 900 million voters in India, and nearly 65 to 70% of them exercised their universal adult franchise just last year and elected a government speaks volumes about the extraordinary journey that India as a democracy has traveled when it comes to instilling faith in our democratic institutions. It's also equally important for us to recognize that this journey of our democracy has also created an extraordinary situation with regard to young voters and young people. While 1.3 billion people is our overall population, 850 million people happen to be less than 35 years of age. And so there is the demographic situation in our country is also equally important when it comes to be recognizing the importance of rights and freedoms. And the new generation of young people are even more conscious of their rights and freedoms and are never reluctant to resist authority and to assert their rights and freedoms. So the third element, which is I think equally important, is that while this journey of democratic evolution has happened, it is equally true that a lot of our rights and freedoms have been undermined, not just now, but even before. And there is a need for continuous reiteration for us to be more, sanguine about the future. Eternal vigilance is the price of liberty. And there is no doubt that this effort today that is being undertaken as a part of this program that Henry and his colleagues are leading it at the People's Watch is also an example of why we should continuously contribute towards building collective consciousness towards the protection of human rights. It's also equally important that human rights is also suffering from both internal and external legitimacy crisis. And I say this as a human rights scholar also because of the fact that we as people who work in the field of human rights need to constantly strike a very delicate balance. At one level, we need to be conscious of the fact that all exercise of power, both domestic, international, in any form, is if it violates human rights, is resisted, criticized, pinpointed, identified, talked about, written. All of that should happen, and should happen in a free and liberal manner. It is equally important for us to recognize the complexity when it comes to, enforcing human rights and balancing, different types of rights and freedoms with the situations that are prevailing in different societies. If we don't, focus on the balancing act, then we also run the risk of not only becoming irrelevant, but also not being able to appeal to the consciousness of many people who may not necessarily be naturally, educated, or for that matter, deeply committed to human rights in the sense that are working in the field of human rights, although all of which will appeal to them and may impact their lives. So in some ways, we need to evolve a greater democratization of the human rights discourse to be able to make it more and more aligned with the people's aspirations. And this aligning with people's aspirations is absolutely critical for any discourse, and let alone a human rights discourse which attempts to, the goal of which is to improve the quality of lives, to be able to expand their rights and freedoms, and able to fulfill their goals and aspirations. All these objectives are equally important for the human rights discourse. The fourth thing which I think is important for us to do is that not only to stress upon the normative framework of human rights, both domestic and international, but also to strengthen internal institutions within a country towards advancing the cause of human rights. I have to say that as somebody who had worked in the early phase of the evolution of the National Human Rights Commission in India, the days of people like Justice M.N. Venkatachalaya and Justice J.S. Verma, it is only fair to say that we have seen after those years, we saw what I would call a gradual destruction to a very rapid destruction of these institutions. The fact remains that today, human rights institutions in our country and many other countries possibly are indeed suffering from a great challenge of both its own credibility, but also the trust that it is expected to have in the minds of the people and the civil society. We need to work towards, developing that trust, developing the institutional capacity. And I am talking in terms of not only the Human Rights Commission, arguably the National Commission for Women, the National Commission for Children, the Backward Classes Commission, SC/ST Commission, and then you go on to the Central Information Commission, a whole range of institutions. And there are a number of challenges, and let me be very candid about the fact that not everything the government is responsible. I think we should recognize that not all the all aspects of this relevance or credibility deficit that these institutions are suffering can be blamed because of the government, a lot of which also depends upon the kind of people who ended up taking these positions. And we need to figure out as a civil society, how do we resurrect the institutional capacity that needs to be improved in our effort to fight for the cause of human rights. That's on the governmental side. Let me go to the next side, which is a very deeply depressing side for me personally, the story of the non-governmental organizations and human rights NGOs and civil society organizations. Let me be very candid with you. People's Watch and organizations like People's Watch are still far fewer in number and are much, they remain still exceptions. Today, you know very well, and I know it too, a large number of bogus human rights NGOs have come into operations across the country. They are engaged in all kinds of dubious actions, including corrupt activities and other types of vested interests, and even both political and other type of agendas that they are pursuing. And unfortunately, that has expanded quite significantly. Even the time when I have been part of this work for the last over 2 decades, I'm stunned by the kind of organizations that have come in. A lot of, I would say, money has come in a way that it shouldn't have. It has created misplaced vested interest into the whole movement. And unfortunately, when these things happen, the legitimate and credible institutions are also, are under the, they also need to, they are questioned. Their work is questioned. Their work is challenged. So in some ways, the only way to respond to this is that we all have to speak truth to power, but also we need to be able to speak truth about our peers who are maybe in the movement but are not doing the right thing. And that's a very difficult thing, because at the end of the day, fishing in troubled waters means that you, as a human rights organization, you are making yourself vulnerable. But if the human rights movement has to be infused with greater degree of legitimacy and credibility, at least in India, we need to go through this catharsis process whereby we are able to call what they are. And more such organizations need to be taken to task in different ways, public shaming including, so that people are able to recognize the good ones from the ones which do not deserve that recognition. And then I think the fifth one, which I want to say, is that this tragedy of our human rights discourse has now gone to a stage where many dimensions of civil society organizations are also not doing their job that they should be. One obvious example is media. It is only fair to say that a lot of our media, unfortunately, have, let's say, pretty much, lost their way and have not been able to rise up to the occasion, let alone speak truth to power. One thing I will be very clear, governments, regardless of whichever political party is in power, do have a tendency to undermine the ability of civil society organizations, media, as well as even NGOs to from the work that they're doing. That's almost comes with the terrain. But it all depends upon how much integrity we have with us to be able to make our own points in an effective manner. But part of the problem is also about integrity. When you have intellectual integrity in making the kind of criticism you end up making, most governments, and at least I can say this within the Indian context, both state or central, may end up grudgingly accepting, or may not do anything about it, may end up grudgingly accepting what it is. Now, that's a very delicate balancing act human rights organizations and human rights lawyers need to do. And that's there are lots of writings about it, how to manage it, what kind of work makes it effective, how much you push the envelope so that you remain relevant and yet you don't make yourself vulnerable. Lastly, I want to say that there's a very age-old discourse about how much of the work that NGOs and organizations should contribute toward civil and political rights on the one hand, and economic and social and cultural rights on the other. We have come a long way from that discourse, but even today, I do see and read and hear about these discussions happening in the sense that NGOs such as People's Watch, arguably, as some people argue, that they are much more useful and relevant to focus on civil and political rights, including custodial violence and prison and issues surrounding torture and those type of things, and not so much about right to education and right to health and all those things. Very unfortunately, this debate I would have expected should have got settled long ago. If I remember correctly, many years ago, the then director of Human Rights Watch, Kenneth Roth, wrote an article in relation to this precise issue. And Kenneth did argue about Human Rights Watch had a more, I would say, conservative position on the matter. And of course, Amnesty International, Human Rights Watch, all these organizations evolved over the years. And there is no right answer. These people are not as far-sighted then about these things. And there was an internal discussions taking place all the time in international human rights NGOs, how much human rights NGOs are effective. Because you know what? When Amnesty International was able to focus only on death penalty, it could say very clearly their only thing to tell the government was, don't do it. And they were focusing on capital punishment, or you stop torture, or provide, ensure freedom of speech. Those were the argument that the human rights NGOs would make is that civil and political rights are more easy and more predictably possible. And once you enter into education and health, and you enter into budgets, and you enter into choices that governments have to make, and those are political in nature, and human rights NGOs are not capable of doing. We have come a long way from that at multiple levels, including the interdependence and indivisibility of human rights in general. And of course, our courts in India, particularly the Supreme Court of India, has gone so far away in relation to providing a more integral understanding. Our legislation, including our parliament, for example, the Right to Education Act, the Rural Employment Guarantee Act, and the whole range of social welfare legislation has actually given rights-based approaches to development, has been taken into a higher level in India by recognizing both constitutional and legislative evolved rights when it comes to protecting rights and freedom. So I want to end by saying that this extraordinary evolution of the human rights discourse has created new opportunities for both human rights organizations and individuals who are working in the organization. Unlike many other work where you can see a target, you can achieve it, and then you can actually feel a sense of victory. This is not going to be like that. This is going to be a continuous journey. It's going to be relentless. There is no end to it, but the journey should give us enough satisfaction and a deeper sense of democratic engagement that we are able to, in that process, build a society that cares for its people more. More recently, I think we should be conscious of what is happening in the country, including the plight of the migrant workers. Sometimes and I actually will be very, very, I would not blame the government for the migrant workers' plight. It is all of us have to take responsibility. This is not a problem of a state government or a central government. In fact, this is as Harsh Mandar would argue, this is a reflection of the total state of mind of all of us, how much we care about the poor people. And that is reflected in every aspect of our life and governance. And the governments which tend to do what they do or don't do what they should do is a reflection of our own priorities. So in some ways, we have a larger problem at hand as to how do you build a society that cares for the rights and freedoms of people, that cares for the development goals and aspirations of its people, that cares for making people accountable if they end up not doing what they're supposed to be doing. These are the important challenges I believe human rights advocates and human rights organizations need to do as they look at the future. I'm quite conscious of the fact that there is more and more awareness built around it, more and more young people in particular, as I look at my own students in our university, but also other universities across India. But here also, one note of caution, there is enough appetite among the political brass of India to manipulate the human rights movement, to manipulate the thought process of young people, to be able to hijack the agenda and infuse petty political agendas into the human rights discourse. And human rights and politics is not the problem of today. It has always been the case, but the future legitimacy of this movement will significantly depend upon how we are able to maintain integrity and rectitude of the human rights movement itself. It's a call to challenge all of our work, and particularly the work that each one of you are doing, so that we are able to develop a much better discourse and are able to actually impact the lives of people. With those words, I'm sorry I probably have taken more time than I should have, but thank you so much for this opportunity, and it's so wonderful to be here. I will stay for another 15-20 minutes and hear my friend Steve a bit. Thank you so much, Henry, and thank you to all of you for being here, and thank you, Steve, as well. We can't hear you, Henry. We can't hear you.
Thank you so much, Raj. When this is totally unexpected and so kind of you to have done this, and you did it so wonderfully well. And I think it was almost a special lecture that all of us had the privilege of listening. And I mean, you went through areas which I don't want to repeat, but I think all of us have noted. You have spoken about the strengthening the institutions internally in this country. And we did have one module, which was the second module only on that. And we recalled, of course, we recalled the court system, but we recalled the legal aid system and the growth of the legal aid movement. And put it all together. We had courts, legal aid, and national and state human rights institutions together. And I want to tell the participants that Raj was a consultant and research associate at the NHRC from October 1997 to July 1998 on a research project relating to prison reforms, and who submitted a report entitled Standards of Prison Care to NHRC in July 1998. And therefore, what he spoke about NHRC was first-hand knowledge of how things were going on there. And I perfectly agree. You cannot have had a better assessment of the rapid destruction in these institutions that have taken place. We did all this yesterday. And I fully agree with what you had to say about the depressing scene of NGOs in this country. We fully agree that it is important. And the need for us to continue to be intellectually, to maintain intellectual integrity. And we have been doing that, attempting to do that. And I can only tell you, yes, people will grudgingly accept it. People cannot fight it back. They might do some little pinpricks here and there and close our bank accounts and things of that sort. But more than that, the fact that some of us physically are continuing is proof of that. And the one good example that we see, and which you ended up with about the migrant situation, Raj, is that institutions are what people make it. Your university is what you have also made it. I'm sure you have a big, large team, but there are certain individuals who have to also sacrifice and lead specially. And the Supreme Court of India yesterday, after receiving bashing from a variety of sources, suo moto took up the migrant cause. And I was talking to Professor Steve Marks just now and saying, today we saw the reflections in our High Court. And I want this to be mentioned as a sign of hope. My High Court today was talking about migrant labor in a manner that it had not done earlier. My High Court, where I was appearing this morning, spoke about the poorest of the poor and the last rung workers in the government sector who have not been looked after in terms of personal protective gears, etc. And said, no, sanitary workers have to be looked after, etc. So it spreads. So the leaders are good in not only government, but even the judiciary, national human rights institutions, civil society. There's a lot of hope for us. And that is the hope that we are trying to create. I'm so happy that you created that hope in this lecture of yours. Thank you, Raj. Thank you very, very much. Friends, while thanking Raj, I want to also welcome Professor Stephen Marks. Professor Stephen Marks, thank you very much for accepting. It is so kind of you to have accepted this hint that Raj gave, but then you accepted not once, but to be with us today and tomorrow. I'm unfortunately being pressed because there are some bonded laborers from Chhattisgarh and Jharkhand who are just now, as I go down here, being released with the police and the revenue department going and pressing on them in Madurai. And I say they are not migrant workers, they are forced labor, therefore they are bonded labor, therefore they are scheduled castes, they are scheduled tribes from Chhattisgarh, and therefore proceed under the SC/ST Atrocities Act. And that is the reason for these phones going like this. I'm sorry. Professor Stephen Marks is François-Xavier Bagnoud, Professor of Health and Human Rights at the Harvard T.H. Chan School of Public Health, where he directs the program on human rights in development. He has degrees in law and international relations from the Stanford and several universities in France, as well as the Syrian Arabic Republic. He has worked for the United States Senate in Washington, the International Institute of Human Rights in Strasbourg, UNESCO in Paris, the Ford Foundation in New York, and the UN peacekeeping operations in Cambodia, West Sahara. He has taught at the Columbia University and Princeton University, among others, and has been in Harvard since 1999. He is currently Distinguished Visiting Professor and Special Advisor to the Vice Chancellor of Jindal Law Global University, whom we just heard now. His publications focus on international law, development, biotechnology, mass atrocities, terrorism, cultural rights, tobacco control, access to medicines, human rights education, neuroscience, and the right to health. Professor Stephen Marks and I first met when we were dealing with human rights education in schools, a program that we were doing in schools. Thank you very much, Professor, for being here. Professor will today deal with treaty bodies in the United Nations that were introduced to you this morning, and will continue tomorrow with the special procedures and the Universal Periodic Review. Or maybe if he has time, he will advance the Universal Periodic Review today also. Over to you, Professor. All the best. Thank you.
Thank you very much, Henry. Thank you very much, Raj. Given that the time limitations, Raj said so much. There is one thing that I want to say by way of a segue into my topic. He alluded to the need to keep human rights front and center in 5 different dimensions and challenges that face us today. What is interesting that you will be able to discover, hopefully during my presentation and your subsequent work in relation to the United Nations and human rights, is that all the UN bodies and procedures that we will be discussing today have responded to the pandemic, the COVID-19 pandemic with precisely the same message and vision that C. Raj Kumar mentioned, namely to keep human rights front and center. Given these challenges facing us, given their wide ranging of challenge to human life, to employment, to migrant labor, to all of the issues that arise, we need to keep human rights front and center, and each of the procedures that I will be talking about has attempted to do so in its own way. Who is keeping track of time? Henry is left, and I guess.
No, I'm here. I'm very much here. I just.
So, how much time would you like me to take? I have a timer here, and I can keep track.
Like you know the pattern. I mean, 20 minutes and then some question. 20 minutes, some question.
So I'll go for 20 minutes and then stop.
Participants are here till 5:45, 5:50, so you can arrange accordingly.
So first of all, let me warmly welcome the participants. It is an honor for me to be before you today. I want to thank People's Watch and Henry in particular for all they have done to be models for the world on human rights education. Human rights education has been, of course, front and center in my career from the very beginning. I know we shouldn't be taking time to do this, but sometimes it's useful. I know when I was a student, getting a personal anecdote from the lecture sometimes was more important than hearing the substance of the lecture. And my personal anecdote will be that when I started my career, and Henry mentioned that I started at the International Institute of Human Rights, that's a body that was created with the Nobel Peace Prize that was granted to a man named René Cassin, who was the principal author of the Universal Declaration of Human Rights. For the 20th anniversary of the UDHR, that was 50 years ago, he was given the Nobel Peace Prize. And with that, he created an institute. And in employing me in that institute, I can still remember this little man with this little beard looking me in the eyes and saying, you must pursue human rights education everywhere. And I am trying to do that now to live up to that legacy. So let me now move to my presentation. Oh, good heavens, I did not expect this to happen. Please give me a moment. Here we go. All right. So here we are. Human Rights Mechanisms of the United Nations. I've given it a subtitle of Law and Politics. I assume you can all see this slide, correct? Everybody can see the slides? Okay. I've given it the subtitle Law and Politics, and the preliminary remarks that were made by Henry and by Raj, certainly, and your previous discussions on the law and politics of human rights certainly make it unnecessary to dwell too much on the relevance of that issue. What I would like to do is to raise these issues of human rights procedures of the treaty bodies of the UPR, special procedures and so on, but first of all, set it in a broader context of human rights and international law and the UN system. So in order to do that, I want to ask you to think what you want to get out of the next 2 hours and tomorrow morning if I'm still with you. What are the scopes and objectives? What do we hope to accomplish? What will you know tomorrow midday that you don't know today? So I would like you to think about the place of law in human rights work. You've had an exposure to that. That will never stop. Is this a matter of social mobilization, or is it a matter of application of formulation and implementation of law? Second thing is to review the concepts that you're already aware of international law that are necessary to understand where human rights come from as part of the functioning of the international system. And thirdly, we want to bring that down to the means and methods by which the United Nations fulfills its charter obligations to promote and protect human rights. And fourthly, we want to look at the specific human rights procedures. What are they and how do they operate? With, and of course, the main purpose of today's session is item 5 here. What are the 3 functions of treaty bodies? Let that be a little challenge to you. You can see, identify the 3 functions of treaty bodies. By this evening, by 6 p.m. today, I want you all to challenge yourself. I will be able to answer the question to anybody, anytime for the rest of my life. What are the 3 functions of treaty bodies? Are you ready? And tomorrow we're going to look, perhaps I'm going to expose a little bit the UPR, if we have time, and a little more on the UPR. And then tomorrow we'll be able to function in light of the, what are called the special procedures, which have been introduced to you already, and I'll introduce briefly today. You've been given readings from the book that you see pictured here, Human Rights in the World Community. Chapter 30 is the chapter where I tried to summarize all that I'm talking about now. I see a finger raised.
That's me, Mark. Your slides are not moving.
The slides are not moving.
Yeah.
They are for me.
Yeah.
They're not
We are
moving?
still in the first slide.
No, they're moving for me. What is wrong here?
So Steve, is it Henry? Can he send it to one of your organizer?
Yes, yes.
Then
Rajuel, can you pick it, Rajuel?
Yes.
let them have the control, and whenever Steve wants to say, let's move or something.
Yeah, that's what we do.
This is all organized so that I can, well, let me do it this way. All right, now if I do it this way, can you see it?
Yes.
I can see it. We can
All
see
right,
it.
so you're going to have the slides on the left then. I can't do the play function doesn't work. I'll do it this way. So this is what I was showing you earlier. Let me catch up quickly. All right, so you can see the scope and objectives. What do we want to accomplish? And I've identified these 5. And I challenge you with number 5. That's the main purpose today. Henceforth, in your professional careers, you will know and be able to function and apply the 3 functions of the treaty bodies. And tomorrow we're going to talk a little bit more about the UPR, the Universal Periodic Review, and the special procedures, primarily the special procedures. So what I was just talking about when you drew my attention to the fact that you could not see the slides is that the reading that you were given is my chapter in this book called Human Rights in the World Community, in which I tried to provide an overview of the United Nations and human rights. That's really our subject for today. So you have already in your course devoted a lot of time to understanding how human rights are considered as not only a legal matter, but a matter of social mobilization. How do we balance those? You reflected on this. I'm not going to dwell on it. I will nevertheless share with you a quotation from a friend of ours, whom you've all heard of, Amartya Sen, who quite famously said, "The invoking of human rights tends to come mostly from those who are concerned with changing the world rather than interpreting it." And that's what Raj was talking about in the various forces of civil society that are at play. And this is what I understand is your role. You want to change the world. You want to make this world a better place. The colossal appeal of human rights for you has provided comfort for those suffering intense oppression and great misery without having to wait for the theoretical air to clear. You don't need Stephen Marx or Siraj Kumar to theorize about this, to present to you the content of international human rights treaties. You want to protect people who are under harm, even though human rights can and often do inspire legislation, says Amartya Sen. This is a further fact rather than a constitutive characteristic of human rights. So that's the real challenge that I'm sure you've already discussed in this course. If you are if you're engaged in human rights education in order to help people who are suffering, you are deeply influenced by Amartya Sen's idea that this is a framework to change the world, and that the legislative aspect of it, the application of it through the procedures of international law and international institutions, is a further fact. Well, it's not a further fact for this session. It's the central fact. So let me skip to some key concepts of international law to understand why the legal framework and the UN framework in particular is relevant to your task of changing the world. How do human rights become accepted and applied through international law? If the world could change successfully through your grassroots efforts, we would not bother with these institutions, with these ladies and gentlemen in these black robes and so on, who sit in The Hague and render judgments. Who cares when you are changing the world on the ground? Well, we do care, and a whole question confronting you and us is to what extent what these people are doing at this level will have an impact on what matters to you, the people whom you work with. The essence of this, as I said in the overall title, is law and politics. The core framework for international law is the Charter of the United Nations. And the Charter of the United Nations communicates in the legal language of the Charter, which is a binding treaty, a very ambiguous message. It gives an ambiguous vision of the realpolitik, the political reality of state sovereignty, of the functioning of the international system, of governments pursuing their interest and using the international system to pursue those interests. The UN Charter says in Article 2.1 that the UN is based on the principle of the sovereign equality of all member states, and that nothing contained in this charter shall authorize the United Nations to interfere in matters that are essentially within the domestic jurisdiction of states. So, if you take that view of sovereignty, supported by a critical provision of the super treaty of international law, the Charter of the United Nations, the game is over. States do what they want. States carry out their policies, their legislative, judicial, and enforcement functions, the essence of their jurisdiction, they carry it out the way they see fit. And if people suffer along the way, that's up to the governments to decide what they want to do. The same charter, nevertheless, enumerates among the purposes of the United Nations to achieve international cooperation in promoting and encouraging respect for human rights. Now, in 1945, when this was drafted, promoting and encouraging respect for human rights and the fundamental freedoms without distinction as to race, sex, language, or religion was extremely powerful. Today, it's ridiculously small in terms of what we want to accomplish. Nevertheless, this vague commitment to advance the promotion and encouraging respect, that means please, 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 respect for human rights, has a legal obligation in the UN Charter. In Articles 55 and 56, the members pledge themselves, those are the words of the Charter, pledge means we accept the legal obligation to take joint and separate action in cooperation with the organization, with the UN, for the universal respect for and promotion of human rights. So whatever we do now in the functioning of the United Nations, what we're going to discuss today on the treaty bodies and all the other UN mechanisms for human rights, is this balancing act. Now, I was giving you some ancient history when I discussed my time with René Cassin in the 20th anniversary of the Universal Declaration of Human Rights in 1968. Can you think back that far? None of you were born. Your parents weren't even born then. This was the time, what you're looking at now was the state of international law in the UN system at the time. Where have we come since then? This is the principal message that I want to communicate to you today. When we talk about the UN treaty bodies, which is the essence of our presentation today, we are talking about the evolution of this system of sovereignty, states do what they want, and human rights protected by the United Nations. On the other hand, the tension between the two has sort of on on a balancing, on a pendulum, where at the time of the UN Charter, we were lucky to get that language of Article 1.3 and Articles 55 and 56 into the Charter, which, by the way, was born in the same city where I was born. I'll leave for you to figure out what that city was and remember it. Where we've come now is the shifting in the pressure of that to what one of our international law and human rights colleagues in a book called Achieving Human Rights is called responsible sovereignty. He says that sovereignty can no longer be reduced to territoriality. That is, India does what it wants in India, including, of course, the Union Territory of Kashmir, Jammu. Can no longer be reduced to territoriality. It now includes elements of normativity. Human rights, humane governments, human dignity, and functionality. Non-territorial centers of authority and control. Sovereignty needs to be conceptualized as deference to established governmental authority in a state and as a possible basis for endorsing or repudiating intervention to serve humanitarian goals. So again, this is the same balancing of two provisions on the weak UN procedures on the one hand, that's on the left, and this potential for strengthening UN procedures on the right. It is essentially a balancing of sovereignty and the exercise of jurisdiction by states. How does the UN proceed? How do the lofty concepts of human rights have any teeth? We know that in 1945, the UN Charter was adopted. You saw the key provisions of it relevant to our subject today, 1945. In 1948, the Human Rights Council, as you've learned, and you've had several lectures on this, embarked upon the drafting of the Universal Declaration of Human Rights. And from then, we are moving from the standard setting procedure to the norm enforcement processes. And what we are talking about today are the norm enforcement processes. Here in my framework for understanding how human rights move from lofty ideals in the UDHR to something that changes reality is to distinguish promotion and protection. I don't know if you can see my arrow here. This is promotion and this is protection. Promotion involves developing an awareness. What we are doing now in this webinar, standard setting, what the Human Rights Council does when it adopts a new treaty, what the other international institutions do when they adopt a new treaty. Institution building, what happens when you build up the judiciary, the Human Rights Institute, the National Human Rights Commission in India, and the equivalent all over the world. Those are the promotion steps that can be taken to translate human rights from lofty concepts into something that changes reality. And then there are the 5 protection functions. Protection means to do something about it when governments do not comply with their obligations. And that's through monitoring, through adjudication, through political supervision, through humanitarian action, and through coercive action. We'll come back to this, but we don't have time to get into it very much because I'm going to stop in a minute for the first after discussing briefly the concept of norm creation. I said the first step in moving from words to deeds is to have a binding international standard so that you no longer simply have governments relying on their own national laws, and we're going to see examples coming from India in a few moments, relying on their own national laws to say, we will be governed only by our laws. We are a sovereign state. You cannot tell us what to do. Well, in the international sphere, there is an authoritative decision-making process that Amartya Sen calls a further fact, but that is front and center what we're trying to do, that allows a process whereby governments submit to norms established as hard law, as binding treaties or custom. But it's also relevant for our purposes to know what soft law there is. Those norms that are emerging through resolutions, declarations, plans of action, practice, general comments. General comments is going to be one of our subjects for today. So the essence of this balancing act between state sovereignty on the one hand and effective UN action on the other is to have states accept norms and abide by them. And these are the 8 mechanisms whereby we move from one to the other. The norm creating process is essential to understand, to deal with the treaty bodies, which is our main subject for today. Where do these treaties come from? We know there's a treaty against torture. We know there's an international covenant on civil and political rights. We know there's an international covenant on economic, social, and cultural rights. We know there's a treaty on the elimination of discrimination against women, on racial discrimination, on the rights of persons with disabilities. Where do these come from? They all follow this pattern. People like you, NGOs who are concerned that there is a gap in international law, mobilize. They push for governments to take an interest in this and to at least agree for the United Nations to examine the problem. So they do a study. And when the study is over, what happens when you conclude a study on an area where there's been inadequate legal protection? The study usually concludes by saying, well, we need to clarify the norms here. Let's do a declaration. Then you take another decade and you draft a declaration. And the declaration is adopted. Let's take the example of torture. There was a declaration on torture. Discrimination against women. There was a declaration on discrimination against women. That became the reference document, but not binding law, for over a decade in each case. And then they said, we've learned a lot from this. Time to make it binding. So we move from the declaration to a convention. Takes a decade to draft it sometimes. Once it's drafted, you need it to be ratified by states so that it comes into force. And when it comes into force, a treaty monitoring body is established. A group of usually 18 experts who are designated to monitor the application and raise issues for the implementation of the treaty. And as you know, there is also a process whereby individuals can complain to that treaty body that their rights have been violated. That's usually done through an optional protocol, OP. That's the next step. If it's not in the treaty itself, you draft an optional protocol, that has to be ratified, then the treaty body can pass judgment. So this is what I call the norm creating process. That's how we get from, through a normative decision-making process, we get through these processes so that we can have a body with the authority to hold governments to account. That's what it's all about, accountability, norm enforcement, to see that governments respect, protect, and fulfill their obligations under human rights treaties. Now, should we pause here and then I get into the mechanisms? Well, let me first give an overview of the structure of the UN. And then, I'll give this quick overview of the UN structure. I guess, Henry, are there any, is there a good reason to pause now?
Rajwell, any questions that have come, or Matthew?
Yeah, there are 2 questions, but I'll take one at the moment. How do we balance between sovereignty and collective responsibility, that is vis-a-vis gross human rights? For example, responsibility to protect failed in Sri Lankan case or Myanmar, for example. Maybe you can answer now or later throughout your presentation.
Right. All right, so I'm taking you back now, and this, of course, was not a part of the program for today, but I'm be delighted to come back and give you a talk about R2P. In fact, I published something on it in the Jindal Global Law Journal. Remember I was talking earlier about the means of implementation, 3 means of promotion, 5 means of protection. The fourth and fifth means of protection were designed or have evolved, have emerged as a way to address gross violations of human rights. Obviously, when a population is at risk, the international community needs to provide assistance to refugees and to internally displaced persons in humanitarian emergencies, provide for repatriation and resettlement of populations that are affected by gross violations of human rights. But when you look at the situation in Sri Lanka was the example you gave, or in Yemen, or in Syria, or in Myanmar, and so on, you have a situation, Libya, you have a situation in which the international community, if it does nothing, will sit on its hands while hundreds of thousands, if not millions of people are killed through acts of genocide, crimes against humanity, and so on. What has evolved is the possibility, and what was established in 1945 was the possibility in Chapter 7 of the UN Charter for the United Nations Security Council to vote sanctions and to take coercive measures against governments responsible for these violations of human rights. This concept of humanitarian intervention has evolved as a result of the interventions in Bosnia to the emergence of a clarification of the role of the Security Council under the doctrine of the responsibility to protect, which outlines, without changing at all the legal obligation of the UN Charter, the responsibility that states have to ensure that these types of violations do not occur in their country. And if they run into difficulty, that's pillar 1, if they run into difficulty, pillar 2 says the international community is committed to help them. Do you need help providing resources for these internally displaced persons to survive? What can we do to help you? The idea being, we're not telling you you're a violator, we're going to help you. Those are ways of protecting sensitivity of governments to their sovereignty. However, when governments fail in their responsibility to protect, it is the duty of the international community to intervene, to prevent and respond to genocide, war crimes, ethnic cleansing, and crimes against humanity. And the history of R2P, it's been invoked about a dozen times, but in the most important situations, it has failed. So in this framework that I'm giving you, this falls within the coercive action framework. And let's come back to that. Well, let me now put that in the context of what I'm going to talk about now, which is an overview of the UN structure and human rights mechanisms. Okay, shall I go on now to the, and I will keep in mind that question regarding responsibility to protect. Okay. Okay,
yes.
okay. All right, so unfortunately, if I were in the play mode, these various component elements would emerge one at a time. So you have this very complicated framework of the human rights system. Let's put the UN system in context. International institutions for the promotion and protection of human rights are not just in the UN system and not just in the national protection system. This is national protection down here, if you can see my arrow. And this is the UN system, but also regional systems. The Council of Europe, the Organization of American States, African Union, ASEAN, and the League of Nations, the Arab League, the League of Arab States. Each one has a human rights instrument, in some cases a treaty, and a human rights body empowered to oversee the implementation of the norms. Our purpose today is not to look at national protection system, if you can see my arrow here, or regional protection systems, if you can see my arrow here, but to look at one component of the UN system. We are going to look today at the treaty system. The treaty system is distinguished from the charter system in the UN. The UN Charter we've talked about. You saw the 4 articles that I underscored to the Charter. I've mentioned the Universal Declaration of Human Rights. I've mentioned the Human Rights Council, which is the successor to the Commission on Human Rights, which was provided for in the UN Charter. And under the procedures of the Human Rights Council, we have a number of mechanisms that I'm going to talk about in a minute. But our main purpose today is to look at the treaty system. 1966, the Universal Declaration of Human Rights was transformed from a hortatory declaration, a declaration of good intentions, to law, binding law, ICCPR, ICESCR, the 2 covenants, civil and political, economic, social, and cultural. The Racial Convention, Children's Convention, Rights of Persons with Disability, Women's Convention, Convention Against Torture, forced disappearances, migrant workers. These different treaties have their mechanisms that we're going to learn about today. But first, I want to put those mechanisms in the broader framework that makes the question that was asked quite relevant. How do these relate to such things as the Security Council responding to gross violations of human rights? Well, let's take a broader look at the United Nations. The United Nations consists of the UN Secretariat, the General Assembly, the Security Council, the International Court of Justice, ECOSOC, and the International Court of Justice. Those are the main organs of the United Nations. The UN Charter says these are the principal organs of the United Nations. Under the General Assembly functions the Human Rights Council. Reporting to the General Assembly are treaty bodies that function each one under their separate treaties. The General Assembly therefore has oversight over those functions. The Security Council is the only body authorized to use force to stop gross violations of human rights and to establish international criminal tribunals, such as the ones it established on former Yugoslavia and on Rwanda. Now, we have a technical issue. I don't know how clear this framework is for you. I'm going to present it in a different structure in a minute, but the purpose of this is to show you how the main organs of the UN incorporate these treaty bodies here next to the Human Rights Council. And we have, for a technical reason, and this is a parenthesis, since you're all going to become experts on the UN human rights system, you will understand this, and you'll be able to explain this to your staff members or to your fellow students or to your children, why there's a treaty body over here. When the international covenants, see this one, ICCPR, International Covenant on Civil and Political Rights, was established, it created the Human Rights Committee. They called it the Human Rights Committee because there weren't any other treaty bodies at the time. It's human rights, we'll call it the Human Rights Committee. Don't be fooled. That committee with that name, Human Rights Committee, is merely the treaty body for one treaty, the International Covenant on Civil and Political Rights. That's all it does. Now that's an anomaly, so learn that. The treaty body for this group is called the Human Rights Committee. This group, oops, doesn't have one. Back in 1966, nobody ever thought there was going to be a treaty body monitoring economic, social, and cultural rights. Raj referred to that in his statement. He said, we thought we'd come a long way in equalizing these two categories of rights. Well, back then, clearly nobody expected economic, social, and cultural rights to have a treaty body. When they finally got around to creating one, the Economic and Social Council had to create it. That's why this treaty body is over here instead of over here. But for your normal purposes, the CCPR, the treaty body concerned with the Covenant on Civil and Political Rights, is called the Human Rights Committee. The one on the Convention Against Torture is the Committee Against Torture. The one on the Convention on the Elimination of Racial Discrimination is called the Committee on the Elimination of Racial Discrimination. They all have descriptive names except for this one. And this one is over here. That's the only complicating factor. The rest is straightforward. Okay. Now, let me move on. I said there is a Human Rights Council. Brief fact of history: in 2006, the charter-based Commission on Human Rights was replaced by the Human Rights Council created by the United Nations General Assembly. And the Human Rights Council consists of 47 members, excuse me, consists of 47 members, meets regularly throughout the year, and is the political body that oversees all of the human rights work of the United Nations. Okay, so you know where that is. Human Rights Council is here. Now, the UN Secretariat is here. The UN Secretariat has a special unit with responsibility over human rights. That's the Office of the High Commissioner for Human Rights. And the Office of the High Commissioner for Human Rights, this graph is too small for you to see, but you're all smart and clever. It will take you, I would think, no more than 35 seconds to download this from the UN's website. And by the way, here's a tip for all of you that Henry may have already given to you. On almost any subject, you're used to Googling things. There's even a faster way for human rights things. Just enter OHCHR and then anything else you want. You want OHCHR, India, racial discrimination, favum. You'll have immediately the treaty body that has examined India's failure to regard Dalits and scheduled tribes and castes as being subject to the protection of Article 1 of the Convention on the Elimination of Discrimination Against them. That's an example that I'm going to come to later. You can always find these things. So what you have in here is the functioning of the High Commissioner for Human Rights that has a research and right to development unit, a treaty unit, that's our subject for today, a field operations and technical operations unit, and special procedures. So that pretty much explains the staff working in Geneva on these things are divided into these 4 areas. And what we're dealing with today are the folks working in this area, okay? Now, High Commissioner for Human Rights. Created in 1993, the post has been occupied by, and this is an extraordinary feature if we go back to that juxtaposition of sovereignty versus UN action, that tension we were talking about from the beginning of the UN Charter. The history of these people exemplifies that shift from, oh yes, we're functioning under the principle of sovereign equality of states, be careful what you say, you can't criticize states, to a situation of saying, we're going to tell truth to power. And these people led the way. Jose Ayala Lasso was a bureaucrat, diplomat, ambassador of Ecuador. He helped engineer the resolution that created it, and for a few years he kind of managed it. Mary Robinson, you've heard of, former president of Ireland, has been utterly outspoken, free to say whatever she felt was necessary in the interest of human rights. Sergio Vieira de Melo tragically died in a terrorist attack in Iraq, was one of the most accomplished diplomats in the history of the United Nations. In fact, there's a new movie made about him, building on a book that was written by a colleague of mine, the former ambassador to the United Nations, Samantha Power. I highly recommend that to you. He was followed by Louise Arbour, who is a judge on international criminal law and now occupies a high position in the United Nations, followed by Navi Pillay of South Africa, another international criminal law specialist. and followed by one of the most courageous individuals, a prince from Jordan, who didn't hesitate to defend LGBTQ rights and to speak out in the most direct terms about the human rights violations committed by the United States by separating children from their mothers on the border and so on. And the current High Commissioner for Human Rights, who's equally outspoken, and you'll see her statements on almost any issue that arises. Michelle Bachelet from Chile, former president of her country and former head of women's rights. So that's the Secretariat. These folks are here, UN Secretariat. They provide the secretarial services, as we saw here, for the treaty bodies. And now we're going to move on to the role that organizations like those that are represented by many of you attending this course, civil society, can interact with the Human Rights Council, with the treaty bodies that we're going to get to, with the field offices, the High Commissioner for Human Rights, with the special procedures, with the UPR, and that's what we're going to be looking at later on. So let's now review the procedures within which the treaty bodies function. We're going to look at the 10 treaty bodies carry out these three functions. We're going to look at the UPR, we're going to look at special procedures, and we're going to look at the role of the Secretariat. Now, the traditional distinction that is made is to separate the treaty bodies from what are called charter-based bodies. Before the two international covenants, the ICCPR and the ICESCR, before the Universal Declaration of Human Rights was translated from aspirational to binding law, before that happened, the only basis for that shift from state sovereignty, leave me alone, to UN action to hold governments to account. The only basis for that shift was using the UN Charter, the provisions that I referred to earlier of Articles 55 and 56, and the purposes of the UN under Article 1.3. Those are the charter-based bodies, but once treaties emerged, the treaties function only for the states that are parties to the treaty. So if the treaty has 190 so on members, states parties like the Convention on the Elimination of Discrimination Against Women, all of those countries are bound by the treaty. If it only has 110, then it's only those 110 that are bound by the treaty. That's the difference. The charter covers everybody. Now, brief word about other charter procedures. I mentioned in showing you the structure of the UN, the principal organs of the UN. The General Assembly oversees the Human Rights Council. That's a pretty big job. It does something else too that is extremely important for human rights, to understand the role and function of the charter-based bodies before we get to the treaty-based bodies. The UNGA not only oversees and is the body that created the Human Rights Council, but it also is the place where resolutions are adopted that you cannot get adopted by the Security Council. Security Council will be blocked by a veto. You get resolutions on all human rights issues raised at the level of the UN General Assembly, and that's one of the most important sources to show the evolution of the thinking of member states. The Economic and Social Council also has responsibility over human rights and humanitarian affairs for the UN. The Secretariat, we've looked at, a main organ of the UN, that's where the OHCHR, the Office of the High Commissioner for Human Rights, functions. The International Court of Justice, the principal judicial organ of the UN, cannot take action on its own for human rights, but states can bring cases before it on the application of human rights treaties, as has happened with respect to the Racial Convention and the Genocide Convention. And the Security Council, I've already talked about. Those are the principal organs of the UN, charter-based. The UN Secretariat has also created other entities for other purposes that overlap with human rights. The Office for the Coordination of Humanitarian Affairs, they're present all over the world where things go wrong. They have human rights unit, they cooperate with the Office of the High Commissioner for Human Rights. The Department of Political Affairs, that's where the diplomats run all over the world to try to convince governments to behave themselves. They also keep a human rights mandate. Peacekeeping operations. I've been in two of them, as Henry said, introducing me. I happen to have been part of the human rights component of the United Nations peacekeeping operation in Cambodia, where we sought to work with the emerging new government to post-conflict build up a human rights mechanism. So these elements of the principal organs of the UN Secretariat are part of charter-based bodies in this extensive view. But to be complete, and I'm going to be very brief on this because we need to end up soon. The Economic and Social Council and the General Assembly create bodies that are sometimes confused by people that don't specialize in international organizations. They are emanations of the General Assembly that are very familiar to you because they're big organizations with lots of money. United Nations Development Program, UNICEF, the United Nations Fund for Population Activities, UNHCR, the High Commissioner for Refugees, and UN Women. These are all bodies that were created by the General Assembly saying, we're not doing enough to deal with these concerns of the United Nations. We're creating a body to do it, and they can raise their own money and do a lot. That's what UNDP does. That's what UNICEF does, and all of them. And they all have human rights functions, funds and programs in ECOSOC and GEO. And finally, there are entities in the UN system that through the UN Charter, we're talking about charter-based bodies, through the UN Charter are brought into cooperation with the UN, even though they have their own constitutions. The UN Charter is the constitution of the United Nations Organization. 194 countries are members. Specialized agencies such as UNESCO, the International Labour Organization, the Food and Agricultural Organization, World Bank, industrial, there are 15 of them, have their own constitutions, their own secretariats, their own buildings, their own programs, their own budgets, but they're brought into cooperation with the UN, and many of them, ILO and UNESCO being the main ones, have human rights functions. So if we're going to have an overview of the charter-based functions, it's not just these groups, it's also this larger list. So let me stop there, and then I will get into the what the treaty bodies actually do, these three functions of treaty bodies. Are there any questions, or do you want me to give you some examples of reports, general comments, and complaints?
I would suggest that you go ahead with treaty bodies.
Okay, let's go ahead with this. So I hope you've all understood that in the general thinking, before the treaties, there was only the charter. Charter bodies continue to function today. Once treaties were set up, each treaty only applies to the states that have ratified that treaty, not to other states. And those states come under the supervision of a treaty body that has the names that you learned so laboriously a moment ago when I explained to you why the Committee on Economic, Social, and Cultural Rights is over here and the Human Rights Committee is over here. The rest, the names tell you who they are, where they came from, and why they're there. CRC, Committee on the Rights of the Child, overseeing the Convention on the Rights of the Child. Clear. All you have to learn are these two to be fully technically competent and show off to all your friends. Now, so what do these treaty bodies do? We've got 10 of them. Each of the treaties creates obligations. When you ratify a human rights treaty, when a government ratifies a human rights treaty, It is exercising its sovereign authority. You have not violated state sovereignty. Sovereign authority to accept obligations under international law. Primary obligation is the state party accepts to respect the particular rights on people within its jurisdiction. Rights of the child, first obligation of the state to respect the right here within my jurisdiction. That's the first obligation. Another obligation, however, is to submit to the scrutiny of the treaty body through the reports that the treaty bodies, that they are required under the treaty, required as a legal obligation to present to the UN. Secondly, the treaty bodies have developed the practice, after gaining lots of experience and reading the reports of governments and discussing with governments, saying, wait a minute, we've been doing this for 10 years. You don't really understand what we expect of you. Let's clarify that. That's what happens when they draft a general comment. I'll give you an example in a minute. And third, under certain conditions, individuals can submit a complaint saying, hey, treaty body, the government of India has not respected its obligations under the treaty. Help us. So, reviewing reports. Here's another framework to see how this treaty system works. If you take the, I'm going to try to take a clear example here. No, let me just move ahead. You can access this framework and see how each of these treaty bodies can examine reports and examine complaints. What's important for you is to see what is the possibility that you have, those of you who work for civil society organizations and for organizations like People's Watch, as they have done on numerous occasions, I'm sure, to intervene in the reporting cycle. States parties prepare their reports and they present their reports, at which time civil society organizations can submit questions. When they're developing, when the committee is developing the list of issues, after they get the report from the state, they can say, hey state, we want you to examine, when our time comes to meet with you, when we have our dialogue, we want you to examine these questions. Civil society can intervene there. And then the written report comes in and a dialogue takes place, what's called a constructive dialogue with the committee of the state party. And here, input from civil society organizations and national human rights institutions can also provide their so-called shadow reports. Say, okay, UN, you received this document from the government of India. The government of India affirmed this. Here's our information that will help you realize the full picture. Have a look. And then concluding observations are reached by the treaty body that has examined not only the report of the government, but also the information provided by civil society organizations and other UN bodies. They issue concluding observations. And then there's a follow-up procedure, and civil society organizations can intervene there. Here's another way, a simpler way of presenting it. Civil society intervenes here, here, and here in the cycle of state party prepares a report, presents the report is examined, and follow-up is examined. So let's take an example. Way back in 2007, India submitted its report under the Convention on the Elimination of All Forms of Racial Discrimination. And in submitting its report, when it was being examined, the government of India submitted in 2006 its statement. And in its statement, so what you see here is the official document of the Committee on the Elimination of Racial Discrimination. And here you have Mr. Mahanvati speaking on behalf of the government of India, telling the committee that his country was sparing no effort to deal with the problem of discrimination based on caste. It has thus eliminated the concept of untouchability in the Constitution. Nevertheless, the Indian government maintains that the concept of caste could not be included and should not be confused with the concept of race in this convention, within the meaning of Article 1 of the convention. So, the Indian government is telling the committee that's examining its report to say, whatever you're going to say about our compliance with the obligations, the treaty obligations of this convention, don't talk about caste, because that's not part of this. What did the committee say in its concluding observations? This word down here, you see concluding observations. Get used to it. This is another technical term that you're going to come away from today's session very knowledgeable about, and you will look for concluding observations on all reports. The committee takes note of India's position that I just read to you. However, after an extensive exchange, the committee maintains its position that discrimination based on descent includes discrimination against members of a caste and analogous systems of inherited status which nullify or impair their equal enjoyment of human rights. Therefore, the committee reaffirms that discrimination based on the ground of caste is fully covered by Article 1 of the Convention and recommends that India formally recognize, among other things, long report, many details. I've only given 2 examples. Recommends that India formally recognize tribal peoples as distinct groups, urges India to provide effective protection to members of scheduled castes and scheduled tribes against discrimination, and institute mandatory training for police, judges, and prosecutors, etc. Okay. The committee recommends in the end, in its final paragraph, that India should submit its report due in 2010. And we are still waiting. India maintains its position. But there is an example of the problems of the law and politics. India accepts CERD, Convention on Elimination of Racial Discrimination. It submitted its report, said in its report, don't talk to us about caste. The committee said, sorry, India, caste is covered. Report to us about caste. We've been waiting since 2007 for India to do that. Second, role, so that's the reporting procedure. Many, many other examples could be given on the reporting procedure. Second task of the treaty bodies is general comments. Let me give you one example, quite a recent one. Many, many examples of general comments that clarify the obligations that states have. One example of a general comment, just last year, the General Assembly, and I'm choosing this because it's quite controversial and it illustrates that tension between law and politics, between sovereignty and UN action, is the General Comment 36 on the right to life, which discusses arbitrary deprivation of life, the duty to protect life, the death penalty, and relationship with other obligations. And in this document, I'm sorry, I had extracts from it. I'm afraid they're down here. Where was it? Sorry. Anyway, I'll tell you about it and then we can. So in this general comment on the right to life, the committee goes very far in saying that those countries that have the death penalty need to catch up with the rest of the world. The death penalty is not prohibited for countries that have not ratified the additional protocol to the ICCPR on the death penalty or other legal obligations on the death penalty. But they must abide by a whole series of specific requirements on the imposition of the death penalty that are outlined in this general comment, and should move towards the elimination of the death penalty. It also quite controversially dealt with abortion, and in very carefully worded language, essentially took the position that even though many people who oppose abortion consider that it's a violation of the right to life, did not consider that abortion itself is a violation of the right to life, but the right to life must be protected in the context of abortion. And finally, and here's our final role of the treaty bodies, is the complaints procedure. Most committees have an individual complaints procedure for states that have ratified the treaty and that are accepted to be bound by either an optional protocol or a special declaration of the treaty to say an individual or group of individuals, if they've exhausted what's called domestic remedies, they've tried everything under the legal system of their home country and have not got satisfaction, can come before the treaty body with their complaint. So these individual complaints, the individual complaints require either a special declaration under the Torture Convention, Racial Convention, or Enforced Disappearances Convention, where the treaty itself says, if you adopt this declaration, the treaty body can examine the complaint, or they've adopted an optional protocol. ICCPR, ICSCR, CEDAW, Person with Disabilities and Rights to the Child, all have optional protocols. Example. Oh, first of all, and now for organizations like you who may want to bring these cases, at the website you can go to Positions and Inquiries section of the Office of High Commissioner for Human Rights. There's the address, there's the fax number, there's the email. You send your petition in there. Here's an example. Now, here I'm showing off, okay? Everybody in this, attending this, be very impressed. Yesterday, see the big arrow? Yesterday, the Human Rights Committee that oversees the Covenant on Civil and Political Rights issued its final views, its judgment, its final views concerning a complaint that related to facts that occurred in 2009, a complaint that it received in 2013, and 7 years later reached its conclusion. Here's what it's about, and I'm going to conclude with this. You'll see the three different things that the treaty bodies do. The author told the committee, wrote that letter. I gave you the address. You can do the same thing with your clients in India. Told the committee that in 2009, the author's son was coming home from the gym, was stopped by the police. They wanted to open his bag. He refused to let them. Then a few hours later, the mother was informed that her son was dead. And after 5 years, that we're dealing here with Tajikistan. This happens to be Tajikistan. I wanted to take a case that was very, very recent. And after 5 years of efforts, the state party failed to conduct any kind of investigation into her son's death. And the author emphasizes during that period, she had very limited access to the case file and so on. So the author claims that the state party has violated the son's rights under Articles 6 and 7, which relate to torture and the right to life. What this committee does then is to look at two things: admissibility and merits. Admissibility, they ask, did you exhaust domestic remedies? Is this a violation of the covenant? Have you provided sufficient evidence? And the committee concluded that there was sufficiently substantiated evidence and declares the communication admissible, then proceeds to merits. Learn that phase. You have to prove that you've exhausted domestic remedies, you've tried everything in the home country, that there's a substantial evidence in this case, and that actual rights in this treaty have been violated. Then on the merits, the committee concludes in the light of the states parties' inability to rely on adequate and conclusive investigation that her son died as a result of torture. Of any further evidence, and acting under the provisions of the protocol, has concluded that the state party has violated the convention and therefore is under an obligation to provide the author with an effective remedy consisting of 3 parts: conduct an investigation, you can see I'm sparing you the details, keep the author informed, and provide the author with adequate compensation for the violation of her son's rights and with adequate rehabilitation. So those are the 3, come back to the list. Those are the 3 functions of the treaty bodies. You've seen an example of a report, you've seen an example of a general comment, and you've seen an example of the complaints. So I better stop there and take questions. It's been 1 hour I've been speaking.
You take a break. Matthew?
Yeah,
I'm taking questions.
Sorry, Raj. Yes, Raj.
Yeah. Thank you, Professor Steve. There's one question related to ratification of the international conventions and covenants. So what is the legal obligation of a state if it has not ratified a particular convention with respect to that particular convention?
Very good question. See if I can find a it relates to binding norms and norms that bring pressure. Governments, as we saw here, look at Articles 55 and 56. This one, all members pledge themselves, that means accept the legal obligation under the UN Charter, which is a treaty, to take joint and separate action in cooperation with the organization for the achievement of the purpose of universal respect for and observance of human rights and fundamental freedoms without discrimination. So, on an issue such as, let's try to get a good example here. There's so many examples. When a state has not ratified, there's so many examples concerning the United States, I could talk until the cows come home about US that ratifies fewer treaties than most countries. Nevertheless, under Articles 55 and 56, has an obligation to cooperate with the United Nations. So what happens is that the High Commissioner for Human Rights, in issuing a statement, for example, I was quoting this example of Said, who drew the attention of the government of the United States that has not ratified the Convention on the Rights of the Child to its obligation to respect the rights of the child and to cease committing gross violations of human rights by separating children from their mothers on the southern border of the United States. Now, he was not holding the United States to a treaty obligation. He was holding the United States to a widely accepted obligation under international human rights law, which, with respect to the specific provisions of the Convention on the Rights of the Child, are soft law for the United States and hard law for the rest of the world. So the standard can still be applied by the United Nations. the Human Rights Council can still adopt resolutions condemning a country for its violations of human rights, both treaty obligations and soft law for those countries. So, and there have been numerous examples. And we're going to see tomorrow when we discuss special procedures, how governments are held to account outside of the legal obligations of treaties. Under the Universal Periodic Review, all governments are submitted to scrutiny for all human rights, including those for which they do not have an explicit treaty obligation. Special procedures we're going to examine tomorrow. There are thematic and country procedures in which individual mandates carried out by special rapporteurs, independent experts, or ad hoc committees examine either a country or a general situation and will hold countries accountable for violations of human rights even when there is no explicit obligation under a human rights treaty. So let me summarize what I've just said. Treaty bodies look at the obligations of states under their treaties as binding legal obligations. The charter-based bodies, the High Commissioner for Human Rights, the Human Rights Council, the special procedures, the Universal Periodic Review, hold governments accountable not only for their treaty obligations, that's part of the picture, but for their general human rights obligations based upon Articles 55 and 56 of the UN Charter. So the short answer to the question is, when a country is not bound by a specific provision of a UN treaty, there are procedures in the UN to hold it to account for violations of those rights. Now, if it's a, this has been that's why the emergence of soft law is so interesting, because, let me come back to this. Sorry, what was that? There. So when it comes to soft law, emerging laws, norms evidenced by resolutions, declarations, plans of action, practice, general comments, and so on, there are mechanisms in the UN that can hold countries accountable for their violation of human rights in those areas as well. That's a fairly long answer to a really important question. Next question.
Yeah, thank you, Professor. The next question is regarding individual complaints. The question is how often these complaints are taken up and what is the remedy that the complainant gets?
Another very good question. Under the individual complaints procedures, let me give you a chance to have another look at under the individual complaints procedures, I should have the statistics, but I don't. It's easy enough to look up. There's in fact a database on the website of the Office of the High Commissioner for Human Rights that can allow you to look under any country, any treaty, and they call it jurisprudence, where you can see whether or not the committee has examined a complaint. As we saw in the Tajikistan case, these are very slow. And many of the complaints are found to be inadmissible. I showed you the admissibility phase of the complaint. The admissibility phase of the complaint. This happens to have been decided yesterday. It's a very good example for me to give you today of a case in which the committee decided yesterday that the case was both admissible and found a violation on the merits. Most cases don't end up that way. In most cases, they say, well, yes, this complaint alleges lots of things, but we don't see much evidence of it. Or they say, well, you didn't try all of it. The government says there are actual mechanisms that can be tried back home. Go back to your home country and try to get an answer there. Or they find that it's admissible, but on the merits, they don't find that there has been a violation. So there are, this is an interesting role, an interesting issue illustrating interdisciplinarity of human rights studies. We're looking at this as lawyers. So we care how to bring a case, how to get the admissibility decided positively, and how to get the merits decided positively. Political scientists and social scientists examine the data. How many complaints were submitted? Which countries? How many for which countries? How many were declared admissible? How long did it take? And all of those data have been the research of Catherine Sekink and a lot of other political scientists who have examined the effectiveness of this procedure. So the question is, how effective is it for these individual complaints? How often are they successful? How long do they take? I don't have those data in front of me, but that can be found. The other question, the second question, is equally important. What happens if the government disregards the outcome? In this case, it calls upon the government to conduct the investigation that it never carried out, to provide adequate compensation for the violation of the rights, and to provide rehabilitation measures and many other things that are sat in detail. I only gave you the briefest versions of it. So this is Tajikistan on the 26th of May, 2020. We will be examining next year what the government of Tajikistan is telling the committee that it's done. The committee will have a follow-up mechanism to ask the committee what it's done and to follow up. Most of the countries, and here here you can distinguish a range of attitudes that countries have towards these procedures. Most countries cooperate with the procedure. If they ratify the optional protocol, they will argue the case. And if they lose the case, many countries find that it's to their advantage to provide compensation, change their law, make some changes. Other countries will hem and haw. They will say, we're working on it, we're trying, nothing is happening. And other countries will simply stay silent. So the problem that confronts the treaty bodies is, how do you deal with that range of reactions? We can applaud, and I can cite examples of this, where the committee has said compensation of this amount, educate, abolish this law, and the government does it. Others where they say we're working on it, and then still others where they do nothing. The committee threatens the country. It goes before the Universal Periodic Review, and so on. But no, there are no enforcement measures that can be taken against a country that fails to abide by the final views of the committee. By the way, vocabulary, you've learned some technical language today. We learned about concluding observations when it comes to examining reports of governments. The judgments of these bodies under complaints are not called judgments because they're not courts. So they call them final views. So if the final views are not complied with, we have a problem, because the only enforcement is pressure, diplomatic pressure.
Okay. Rajvel?
Yes.
Tell me.
Can we? Yes, sure.
Okay. Professor, we'll close for the day. We have come to the end of a long day for the participants as well as you, and for you a long lecture. And I enjoyed it. Let me tell you, I enjoyed it. Every bit of it. We people don't have too much time to listen to good lectures. And we are extremely happy that we had a good lecture from a good teacher. And we'll hold very close to us the materials that you have shared. The participants have already had access to your material that was shared to them. And I already warned them this morning, and the last slides of the morning were on concluding observations, on general comments, on the treaty monitoring bodies, and I'm sure now they saw it concretely with you. Thank you, Professor. Friends, we will reassemble tomorrow morning, 8:45, to make sure we start our class exactly at 10, exactly at 9, and we will have class till 10:30. So we will have time to do special procedures which have been introduced today. I will share with Professor the PowerPoint that we used this morning, so that he knows what exactly has taken place, and he will proceed from there.
Excellent.
Now to some logistical announcements. Please get off your group meetings. Facilitators, kindly record the absentees in the group meetings. Your meetings have to be short, and at the same time see that everybody is present. And if any absentees, put them in your report to Ganesan, and we are looking forward to your feedback as well. So facilitators' feedback, please send it to Ganesan as you always do, if possible at night. And I think people like Saji and all who meet in the mornings, I mean, your routine can continue as routine. All the others meet in the evening. And please review the slides of this morning, which are being shared with you, so that when you come tomorrow, terminologies are not new and everything else becomes easy for you all. Okay, so let's close for the day. Thank you. It has been a long day, but a very fruitful day. And we are extremely grateful to Professor Stephen Marks for being with us. And tomorrow we will meet again at 8:45. Thank you. Thank you, Professor. Thank you very much. Tell me, Ma. Sorry, I've just